Hello, this is Monica Rahar, and today we'll be discussing a Supreme Court decision which is dated 19th of August 2020. The name of the case is Mohd Anwar versus the State, N.C.T of Delhi. It's a three-judge bench decision of the Honorable Supreme Court of India, and the bench consisted of Honorable Justice N.V. Ramana, Justice S. Abdul Nazeer, and Justice Surya Kant. Now, two primary issues which came for court's consideration in this matter were whether the defense of insanity and juvenility can be raised at the appellate stage. The second issue with respect to which the court reiterated the settled position of law was whether reappraisal of evidence can take place at the appellate stage. Now let's proceed and discuss the facts of the matter briefly. So a victim who later turned into a complainant. So the victim complainant, he was assaulted and a sum of rupees 30,000 which he had with him was extorted from him by a group of three boys who were armed with a knife and a revolver, and this group, it also included the present appellant Mohd Anwar in it. And this entire episode, it took place during night. Therefore, the following evening, the victim lodged an FIR with the concerned police station about the entire matter, and the FIR was registered against three unidentified person. And then eventually, on suspicion, these three accused, they were arrested. And while they were apprehended, two aspects which we need to look into were that they confessed their guilt, or they confessed the fact that they robbed the victim, and secondly, a prohibited knife was recovered from them. Therefore, the following day, they were presented before the magistrate for test identification parade, which they refused to undergo. Now, when the matter was before the trial court, 12 prosecution witnesses in total were testified, and this number, it included the complainant himself and also the magistrate who sought to conduct the test identification parade proceedings. Witness testimonies, other pieces of evidence like sketches of knife, arrest memos, and site plan. So these were all, and also the recovered money and recovered weapons, they were admitted in evidence by the court. Now, the primary case or the primary set of contentions which were advanced by the counsel for these accused was that they outrightly denied the fact that they were involved in the case, and secondly, they stated that they were falsely framed in this case because they were unable to pay a sum of rupees 20,000 or so to the police as bribe. So therefore, they were falsely framed in this particular case. But the trial court came to the conclusion that all the accused were guilty of robbery with attempt to cause grievous hurt, and also the factors which played against the accused. The other factors were that non-production of a concrete set of evidence, and second being their refusal to undergo test identification parade. So they were sentenced to 7 years rigorous imprisonment under Section 397 IPC, read with Section 34. So Section 397 IPC, it deals with or it provides for robbery or dacoity with attempt to cause death or grievous hurt, and the punishment for the same is it should not be less than 7 years. While Section 34 of the IPC, it provides or it ascertains individual guilt of a person who is party of or party to or a member of several persons who does or commit a crime with in furtherance of common intention of all. So that is covered by Section 34 of IPC. Along with that, they were also sentenced to 5 years rigorous imprisonment under Section 392, read with Section 34 of IPC. Section 392 IPC deals with punishment for robbery, which is rigorous imprisonment up to 10 years plus fine. And also, if the robbery is committed on a highway and between sunset and sunrise, then the punishment of 10 years, maximum punishment of 10 years is enhanced to 14 years. And then along with that, they were also sentenced for 2 years rigorous imprisonment under Section 25 of the Arms Act. Section 25 makes certain offenses punishable, like manufacturing or supply of arms. So there is a long list of items which are included in the section, two being the two elements of it. Now, along with that, they were also fined. A fine of rupees 5,000 was also imposed on them. Now, the aggrieved by the decision of the trial court, these accused, they prefer an appeal before the Delhi High Court, and the Delhi High Court convicted the appellant here in under Section 394 of IPC instead of Section 397. Section 394 deals with voluntarily causing hurt in committing robbery, and the punishment for that is life imprisonment or rigorous imprisonment up to 10 years along with fine, compulsory fine. So the reason for, and also when the charges were shifted, that is from section 394, from 397 to 394, the sentence was also reduced to mere 2 years, and there were three primary reasons for that. A, absence of attribution of any specific weapon to the appellant. Now, what happened was when the FIR was lodged, then the complainant did not specify the fact that he was in a possession of a revolver. This fact came later on. So, noting this inconsistency in the testimony of the complainant, the court reduced the sentence, and the other two factors which played against the appellant, which made sure that the appellant is convicted with something. So they, with some section or with a certain amount of sentence, these were lack of animosity or motive for his false implication by the appellant. So the court noted that there was no motive for the appellant to falsely implicate, for the victim to falsely implicate the appellant in the case. And second was consistent testimonies of the witness, which proved the fact that the appellant was involved in the act or the crime. Now, interestingly, additionally, a plea of insanity and juvenility, it was raised by the appellant for the very first time before the Delhi High Court, and in support of his plea or claim, he presented two sets of evidence, A being a copy of an OPD card, and second, a statement of his mother on affidavit. Now, in the statement, his mother basically claimed, she claimed that the appellant, he was undergoing treatment for insanity with a government hospital, and she used to chain him in their home in order to prevent him from harming someone else and also his own self. So this was to support his plea of insanity and juvenility, but the court did not get satisfied with the same, and the court in fact noted that the appellant was above 18 years when he committed the crime. Now let's proceed with the reasoning and decision of the Supreme Court. So the we'll be dealing with the Supreme Court decision in under four heads. The first head being appraisal of evidence. So this is the answer to the second issue of law, which we discussed earlier as well. So with respect to whether appraisal of evidence can take place at the appellate stage, the court noted that appellate courts ought not to routinely reappreciate the evidence in a criminal case. The trial court is best placed to holistically appreciate the demeanor of a witness and other evidence on record. Hence, given the concurrent findings of lower courts, that is the trial court and the Delhi High Court, the Supreme Court did not find it a fit case for reappraisal of evidence. Now, with respect to the first issue of law, that is plea of insanity and juvenility, the court noted that unsoundness of mind under section 86 of IPC, which is the defense of insanity, which states that nothing is an offense which is done or committed by a person of insane mind or insane mental state. So, unsoundness of mind under section 84 of IPC or claim of juvenility, it ordinarily ought to be raised during trial itself, because when it is raised at the appellate stage or belated claims of such sort, it undermines the genuineness of the case of defense. And also, with respect to the same, the court noted that in order to successfully claim defense of mental unsoundness under section 84 of IPC, the accused must show by preponderance of probabilities that he or she suffered from a serious enough mental disorder or infirmity which would have affected the individual's ability to distinguish from what is right and what is wrong, and also which does not make the appellant or the person concerned here who is involved in the crime to know the consequences or nature of his act. And thirdly, with respect to the same plea, the factual aspect of it, the court noted that no evidence of his juvenility, be it birth certificate or school record or medical test or expert examination, were produced before the court to ascertain or to support the fact that he was a juvenile, And also the court noted that in his statement, which was recorded under section 313 CRPC, which essentially talks about power to examine the accused. So the court said that under this statement also, the appellant did not raise the same plea, and the appellant stage, the way he was answering, so his mind or mental state did not throw light on the fact that he was insane or a minor. And also this coupled with the fact that the appellant, he ran after committing the offense and he avoided the test identification parade, and also was not traceable for 10 years in a row after he was released on bail. So these prove the fact that the conduct of the appellant was that of a major, and therefore the court concluded that the appellant was in fact a major. And then, with respect to the prayer which was sought by the appellant as to whether the impugned order or orders be interfered with or not, so the court stated that given such inability of the appellant to establish his juvenility and insanity or raise any doubt regarding his guilt, and considering the detailed reasons accorded by the High Court of Delhi, the reliable testimony of 12 witnesses, as well as the leniency shown in sentencing by the High Court, the Supreme Court found that there were no reasons to interfere with the impugned orders. So this was about this case, and this is a table which shows the abbreviations which we've used in the case note for your kind consideration. That's all we have for this case. Thank you for being with us.